what reasoning was given by the court to apply this embargo, this suppression order? I mean, generally you need a fairly good reason in order to prevent non-accredited journalists from being available. What did they say to that?
Well, it's interesting because New Zealand, in theory, is committed to an open justice regime. And what that means is that, the public are allowed to know what happens in court cases, which is obviously a really important part. The third sector of our democracy is the judiciary, the media and the executive and so on. And the difficulty seems to lie, for reasons that are not clear, between the Criminal Procedures Act, which requires a journalist to be an accredited journalist with either the Media Council or the Broadcasting Standards Authority. So that means that their employer and they are signed up, and that the provisions of those organisations can come into play if the reporting is not factual or if somebody wants to complain. This case is not a criminal case. This case is a civil case. And there is another act that covers the way that journalists are defined in order for them to appear in cases. And that is the Evidence Act. And the Evidence Act is far less definitive about what a journalist is. Basically, don't ask me to quote it, but my reading as a layperson is that a journalist is somebody who turns up at a hearing to report on it. There aren't any particular criteria that they need to meet. So it's not clear to me why criminal provisions are being cited for what is obviously a civil case. It seems like overkill.